It's okay to start?
Yeah, we're on.
Okay. はい、では、時間になりましたので始めたいと思います。このセミナーは、米国特許に関する20分程度のショートセミナーで、ランチタイムに気軽に視聴できるように毎回短い内容でまとめられています。講師は、米国特許弁護士のブライアン・エプスタインさんです。ブライアンさんと、お呼びするんですけども、ブライアンさんについて最初少しご紹介したいと思います。ブライアンさんは2007年から日本企業を主なクライアントとして米国特許出願の代理人をしていらっしゃいます。分野としましては電気通信や半導体、コンピュータ関連発明、医療機器など多岐にわたる発明分野を扱っていらっしゃいます。日本にはよく来られるということで、これまでに合わせて16回来日されたそうです。来日された際にはよく講演をされていまして、過去には政府系のシンクタンクである経済産業研究所で講演をされたことがあるそうです。そしてプライベートでは2015年に東京マラソンに出場され、見事完走されたそうです。また、納豆が大好物だということです。はい。そんなブライアンさんにこれからセミナーをしていただこうと思います。では、ブライアンさんに交代したいと思います。So, okay, Brian さん、it's your turn. Please go ahead.
Oh, Kimi, thank you very much. Yokoso, everyone. This is ExaminIrks session number 2. My name is Brian Epstein, and we are assisted by Oshima Yoshitaka-san of Beikoku Patent Lab. Today, we will get into a bit more detail about how applicants' representatives should be prepared for interviews. And in particular, we will focus on having a strategy. So, U.S. prosecution can be quite a bit more freeform than, for example, European prosecution or Japanese prosecution. And frequently, I hear from examiners that, they'll be conducting interviews with other attorneys, and the other attorneys will say something like, well, what should I do? Or what should my applicant do? And, in theory, this is an okay idea. Representatives typically are generalists. We take clients from the public. We need to handle whatever technology, our potential clients produce. We run the gamut from mechanical, electrical, biological, chemical. And in contrast, examiners are subject matter experts. Not only are they concentrating in a particular kind of technology like software all day, but, it's a very narrow slice of software. And so, like I said, in theory, this makes sense for the representatives to ask the examiners for help. The problem is that, our examiners do not know the invention necessarily. In the U.S., our examiners often do not read the application to learn the invention. And they also don't know the applicant's business needs. They don't know things about, divided infringement. They don't know about, who their competitors are. And in addition, examiners just seldom draft claim language. They look at claim language all day. They have some idea of the sorts of things that attorneys produce, but, they don't really have experience drafting meaningful claims, having structure in their claims, Like I said, avoiding divided infringement concerns. They just, if you look at the raw amendments that examiners suggest for examiners amendments, frequently we have to massage them before we present them to the clients, because there's just no way that a client can accept an examiner's initial amendment. So what should representatives do instead? They should ask focused questions. So one example would be, would prosecution advance if claim 1 included feature X? Frequently I will begin my interviews by discussing the invention. I'll point to the figures, maybe point to key portions of the specification. And, examiners can appreciate a specific claim amendment like that. And if, they don't seem to think that the amendment will advance prosecution, we can just place it into a dependent claim. Another type of question that it's okay to ask your examiners is, would you consider this amendment under the After Final Consideration Pilot Program, AFCP program, or would this amendment likely require a request for continued examination, an RCE? Examiners love this question, actually. Having spoken with examiners, their biggest question going into an interview is, what is applicant really going to do? If I, as the examiner, say, they need to appeal, are they going to appeal? If I find these amendments persuasive, will they really file them? And so when the representatives ask, is this going to require an RCE? Will you consider under the AFCP? Examiners want to give you a true answer. They want to, have you do what they want, something predictable. So if they say, yes, I will consider under the AFCP, they know that you will do that, or they expect that you will do that. Another good option is asking about appeal strategies, not to be confrontational, but, do you think this is likely to be upheld during a pre-appeal brief conference? Would you recommend going to a formal appeal? Most examiners understand that appeal is just a typical transaction that occurs during U.S. patent prosecution, and they take it professionally. Reasonable minds can differ, and they want to know, again, they want to be able to predict what you are actually going to do. And so these kinds of questions are very reasonable to ask your examiners, rather than, hey, I don't know what my invention is. Can you, Mr. Examiner, please tell me what you are likely to find persuasive? Don't do that. And the reason I mention that is that, representatives really need to have some sort of amendment plan. And so the complaint that I hear from examiners is that sometimes representatives have speculative amendments that are not shown on an interview agenda. And what I mean by that is, we get into the interview and the representative says something like, well, I guess like what I said 2 slides ago of, what if I put in feature X or feature Y? Frequently the interviews go in unexpected directions. we can't possibly predict with certainty how an examiner is going to interpret the existing claim or proposed amendment. And so we have to be, the phrase in English is quick on our feet. We have to be, very responsive to our examiner and be able to present a cohesive argument when we've never heard a particular interpretation before. And so we have these speculative amendments of like, well, you said A, and so I will amend to say B. And so the issue is that in some cases, it's unclear how this amendment is responsive to the examiner's view. Just having an amendment as a fallback position doesn't mean it's going to be useful for addressing the examiner's position. Your examiner is going to want to know, has the client authorized this amendment? Again, the examiners want to have some sense of certainty or at least predictability as to how prosecution will develop. And if I go in and say one thing, this is what I'm thinking about amending my claim to say, and then I send it to my applicant and the applicant says to do something different, some examiners get pretty upset. Usually I try to give them a courtesy call of like, hey, just wanted to update you that the applicant's going in a different direction. I apologize. It's just a quick professional courtesy call. And they seem to appreciate that. They seem to understand that happens sometimes. The other issue with these speculative agendas, of course, is that it can be unclear how the amendment actually advances prosecution. Again, it's great to have a fallback position to present to your examiner during the interview, but if it doesn't move prosecution forward, it's just adding additional language to a claim. And your examiner is not going to be particularly happy with that. So what should applicants' representatives do instead? I like to begin my interview, as I said, with an explanation of the invention to provide basis for amendments. And this holds true even if I'm going to argue the rejection. The reason is that, again, I can't predict what the examiner is about to say. And, I'll present arguments and that I find persuasive. And my examiner might have some new interpretation I'm not used to. Maybe I made a technical error. Maybe the examiner made a technical error. And, maybe I'm pointing to a particularly relevant portion of the prior art, but my examiner is instead ignoring that portion and instead taking a broad interpretation of a different portion. That's very common. And so again, I have to propose an amendment. And if I had begun my interview simply by presenting the arguments, I wouldn't have a basis for explaining my amendment. In contrast, when I begin by reviewing the invention, when my examiner says, well, that's great, Brian, but here's this different interpretation, I can suggest an amendment. And then when my examiner says, like those questions on the previous page, how is that responsive? How does that advance prosecution? I can say, hey, remember 5 minutes ago when I explained what the invention is and I pointed to the figure? I'm suggesting this amendment because this ties back into it. And here's how this amendment addresses your interpretation. And it's not just addressing the interpretation you gave it during the interview, but it's also tying back into applicant's invention. So this is a particularly meaningful amendment. And, you know, when I propose these to the examiners, they seem more likely to accept them because, again, this is directed towards the invention. When I propose them to the applicants after the interview, they seem more likely to accept them because, again, it's very much in line with their idea about the case. Generally, it helps, the representatives seem more competent. It's true that I could propose some amendment that doesn't necessarily tie into my invention, but then your applicant is left wondering whether you really understand it. Your examiner is kind of wondering, why you chose this thing. And, this invention explanation, like I said, it really gives an alternative ground for your amendment. Sometimes your examiner's view prevents additional amendments in a particular direction, right? You might have arguments in, heading this direction, and if your examiner doesn't agree, maybe you have amendments in that direction as well. But I'll frequently do interviews, and then my examiner takes some sort of unexpected interpretation, and I realize that, not only can I not present my arguments effectively, but if I propose these amendments, or sometimes we even discuss these amendments, my examiner is not going to buy these amendments. And so it's better to have a high quality backup plan, a high quality plan for a different amendment ready to go. So that's pretty much it for today. Our goal for this series is to keep it around 15 to 30 minutes. We really appreciate you joining us today. Thanks a lot, everyone. Have a good day. See you in 2 weeks.